Welcome to 401k Real Chat. This is Fred Barstein, contributing editor at wealthmanagement.com's RPA Omnichannel and CEO at TRAU, TPSU, and 401k TV. I invite the most interesting, innovative, and impactful retirement and wealth management professionals, asking them to provide open, honest, and candid answers to three important and difficult questions. So let's get real. Today we are speaking with Matthew Eickman, who is the Chief Legal Officer at the Fiduciary Law Center and has had a long history as a retirement plan advisor and ERISA legal counsel. So welcome, Matthew.
Thanks, Fred. It's good to see you again.
Good to see you. So my first question is, there's been a ton of ERISA lawsuits in the last decade, but not much in the mid-size and smaller plans. But yet there's a lot of wisdom, I think, to be gleaned from these cases that all plans should heed, even though they may not be sued. Can you give us a few examples of those?
Yeah, definitely. And Fred, I think it's been interesting to think about the different lessons we can pull from litigation over the last 10 to 15 years. If you and I were having this conversation 10 years ago, maybe even 5 years ago, what we would discuss is what was in the pleadings. We would discuss the plaintiff's arguments, and then we would say to plan sponsors and committees, hey, you should pay attention because there's these types of allegations that are out there that you should be aware of. But really, as we think back to the United States Supreme Court's ruling in Hughes versus Northwestern, and I think a lot of people wondered what the long-term impact of that might be. And I think the number one impact, whether it's direct or indirect, is that more cases now have moved through a motion to dismiss. And so, Fred, rather than us merely say, hey, what are the plaintiffs alleging? Now we're able to say, what are the courts saying in reaction to those allegations? And so we've got a run of 3 fairly recent cases where we have, actually a motion for summary judgment or an actual trial that leads to an opinion from the judge, where I think there really is, as you said, some wisdom that plan sponsors can take from those cases. And I think it's worth walking through and talking about each of those separately, just to ensure that advisors and plan sponsors understand, like, hey, we're not talking about litigation from a scare perspective, but instead, how can we do this right?
That's great. So can you give us a few examples of those?
Sure. Well, I'd start with, Nunez v. B. Brown Medical, which was an opinion issued in August of 2023 from a federal district court in Pennsylvania. And this is a case that every advisor should go out and find the opinion and read through the opinion, because it provides the advisor a lot of ammunition and opportunities to accentuate their services for their clients. This was kind of your old-fashioned run-of-the-mill 401k plan fee litigation suit, where the allegations were that, hey, the fiduciaries could have used lower cost funds and they didn't monitor what the record-keeping expenses were. Well, this went all the way to trial. And the court took in all this evidence, listened to all the evidence, and then in the report, or in the opinion, that is, that the court produced, the court said, you know what, this committee engaged in objectively prudent conduct. Okay, well, that's good to hear. But what's really, really valuable here is that the court went through in painstaking detail and gave the committee credit for the work it had done. The court said, hey, this is a committee that met regularly during the last 6 years. And you know what it did? It provided a bullet point list of the dates on which the committee had met 27 times over that 6-year period. And then the plaintiffs had said, well, you never really paid attention to the investment performance. And the court was able to say, actually, we've got 12 sets of minutes where the committee talked about investment performance. And then the plaintiff said, well, you didn't really address revenue sharing. And the court said, actually, there's 11 different sets of minutes, and bullet pointed the dates of those minutes where the committee talked about revenue sharing. And then finally, when the plaintiff said, hey, you didn't really benchmark or performing your due diligence on your record-keeping expenses, the court said, well, actually, in addition to running an RFI and running an RFP, there were 5 different meetings where you talked about what those record keeping expenses looked like. So this for me, Fred, is like a roadmap type of case that advisors should look at and say, wow, this is a court that said these fiduciaries did it well and therefore there was no liability.
Can you give us a couple other examples?
Yeah, absolutely. And I'll be briefer on the next two. The second would be Silva v. Ivonic. And this was an opinion issued in June of 2024 by the District Court of New Jersey. And we had kind of similar allegations in this particular situation. And here what we had was a motion for summary judgment. So that was, where we have the defendants have said, hey, we've been through a little bit of discovery, we've provided information. Hey, court, before we even go to trial, you should go ahead and dismiss this case. And the court said, you're right. You've put forth enough facts that show that you acted prudently. And there's a very interesting line in this opinion that I think advisors should pay attention to, as well as other plan fiduciaries. So one of the allegations in this case was that they went through a record keeper RFP and they didn't make a change over to a cheaper option. And here's the quote that I think is really important. A fiduciary need not accept drastic changes to the plan simply to attain the lowest fee, end quote. So this is, and I forgot to mention that when we were talking about Nunez v. Brown. In that situation, the committee went through an RFP and actually chose a slight increase in the record keeping expenses with the new record keeper. And here in the Silva v. Ivonic case, the court said, hey, you don't have to be cheap. If you go through an RFP and you find something that's a little bit cheaper, you don't have to go through that move. And so I think, Fred, that's a really good example and maybe a reminder that it's value that matters more than just cheap. Value trumps, a chase for just the cheapest fee. And then the other case, go ahead, Fred.
It could also apply to the advisory fee as well, right?
It absolutely could. And I think that's a really good point. Advisors thinking about being able to kind of justify and validate their fee if they're performing more services for a particular client, then the courts would look on that favorably if the fee were a little bit higher. And in fact, that's the case in both of the lawsuits that we referenced, where the court said, hey, if you're getting a little bit more, then that's okay. You don't have to pay the cheapest. And then the third one, and here's one, Fred, that I'd say every advisor should also look into. It's In Re Quest Diagnostics ERISA litigation. So the District Court of New Jersey issued this opinion in September of 2024. And this is one where the allegations were that the fiduciaries, they'd breached their responsibilities with respect to 2 of the core funds as well as the target date fund suite. So the court granted the motion for summary judgment, in essence, ruled in favor of the defendants, in favor of the fiduciaries. But here's why I think advisors should look at this. The court walked through a number of steps and said, essentially, hey, look at the following things that the committee did that genuinely show and indicate prudence. And you know what the number one thing on that list was? The court gave them credit for engaging a fiduciary investment advisor. Hey, advisors, if you're looking for some sort of advertisement, perhaps from the courts, that would substantiate or validate your value, recognize that in this case, the court said, your fiduciary duties impose a high bar. You went out and hired an advisor to help you with those. That is a good positive step. And that's another positive lesson, I think, rather than advisors can take from this recent litigation and take out to their clients.
Because there still are a surprising number of plans of a significant size that do not have an advisor.
Absolutely.
90%, that means 10% of that
Right.
plan don't.
Right.
So how can advisors use these lawsuits to motivate their clients to do the right things, like creating a committee and good governance to help them and their employees?
Well, it's interesting. As an ERISA attorney, you might think that I would like to talk about litigation because it would scare plan committees, it would scare plan sponsors. And, from my perspective, I found that that's probably not the best way to motivate positive behaviors. The good thing about these recent litigation outcomes is they actually allow advisors to have a different, more positive, more constructive conversation with clients. So instead of saying, hey, look at what these plaintiffs are alleging around the country, you should do something different or you're going to get sued. What about instead being able to say, the courts have put out this path to prudence. The courts have said if you take these steps and you do those things well, that you can protect yourself and you can help your participants. And my firm, my advisory services can help you to do that. It's such a better way to create that foundation within the relationship. And so when then if you can get into that opportunity where the plan sponsor or the committee or the trustees are saying, yes, we want to hire you advisor to do this work, you're able to say to them, well, look at these specific steps that the courts have blessed as demonstrating or indicating prudence. The courts say you should have meetings. So let's have meetings and let's document those meetings. We should have minutes that help to document the minutes that we have. We should ask about investments and revenue sharing and record keeping expenses. We should run RFPs. We should indeed have RFPs on any type of plan related services and expenses. And I find, Fred, that there's that old kind of carrot versus stick comparison. And it feels like the pendulum has swung maybe a little bit to that ability to sell with the carrot instead of sell with the stick, which just creates a more fun environment in which to work too.
And then when another advisor comes in and says, hey, we can do this cheaper and you have to use us because we're cheaper, you can use those cases, some of those cases that you mentioned. So what are some of, give us an example of a bad lawsuit, or it just, and there are going to be some pundits in the industry to say all the lawsuits are bad, because they only benefit the plaintiff's bar, which I take umbrage with, because I think they've done a lot of good in some ways. But what are some of the ones that you think are problematic?
Well, first of all, I fully agree with you. I think um, retirement plan litigation in general has led to a cumulative positive impact for plan participants, which is really aligns with fiduciary responsibilities to begin with. It hasn't always been the most fun or smoothest path to get from where we were to where we are, but generally speaking, it's been a net positive. With that said, there's been an interesting, I would say, bad run of lawsuits that were filed with respect to one particular index target date fund suite. And the general, and I'd say almost lazy argument from the plaintiffs in those cases was, hey, you chose an index target date fund suite, and my gosh, the only reason you would have picked those is that they were cheap. And if you pick something only because it's cheap, then you haven't fulfilled your fiduciary responsibilities. Well, if we back up a little bit, we find that in those situations, I think the plaintiffs are probably talking out of both sides of their mouths a little bit. So we've got more than a decade of them, kind of leading the race to zero and driving fees down as low as they can and filing lawsuits saying, hey, you used an active target date fund suite when you should have used passive. And then we have plan sponsors here who are using a passive suite. And this is, I think, really important. A passive suite that's performed pretty damn well. A passive suite that stands up to objective and quantitative scrutiny of whether it would be prudent to use those for participants. And so I find those, Fred, to be bad lawsuits because I think they take away the focus from value and they get to cost, but again, they're inconsistent with this general argument that things are supposed to be cheap. So, the plaintiff's bar kind of wants to have its cake and eat it too in that respect. And I would think those lawsuits are probably the worst run of lawsuits that we've seen in the last few years.
And I think you also mentioned manipulating the benchmark as well, whether it's
Yeah,
for
that's
keepers or investments.
yeah, that's a great point, Fred. It's interesting. We haven't seen it as much in that specific run of lawsuits that I just referenced, but if we pull open the pleadings that relate to target date funds, and there's some big class action lawsuits suggesting that committees should have chosen different target date funds. Sometimes those complaints have arbitrary endpoints. So if you look at a performance measurement and you see that they're measuring performance as of the end of May of a particular year, we know that's not the end of a calendar quarter. It's not the end of a year. So that's fairly obvious that that's arbitrary. In fact, there was a time when the same firm had filed two lawsuits alleging that two different plans should have used the passive version rather than the active version of one specific fund manager's target date funds. And they chose different endpoints in the two lawsuits. One went through May and one went through the end of October. Well, neither of those are the end of a calendar quarter. Neither of those are the end of a year. So we know that there was an arbitrary decision, or perhaps not so arbitrary decision on the plaintiff's part to choose the endpoint for that measurement.
Great. Well, that's all the time we have today. We're hoping that we can chat some more about with Matthew, because he has both the legal experience, but then he spent quite a bit of time being an advisor. So what he knows about working with plan sponsors and participants. So thanks a lot. Matthew, again, is the Chief Legal Officer at the Fiduciary Law Center. Thanks for your time today, Matthew.
Yeah, thanks for having me, Fred. Thanks for the conversation.
Thank you. And thank you for watching or listening to 401k Real Chat on wealthmanagement.com's RPA channel.